Good morning. Good morning. Our next case is State versus Miller, and we will hear from the appellant.
Thank you. Mr. Chief Justice, Associate Justices, may it please the court, my name is Kirby Smith, and I represent the defendant appellant, Mark Allen Miller. At this time, I'd like to reserve 5 minutes for rebuttal, please. This case provides this court with a unique opportunity to demonstrate how the words used by the General Assembly should be interpreted according to the definition our legislature has given them. The facts of this case are fairly straightforward. On the morning of November 8th, 2018, the Henderson County Sheriff's Department executed a search warrant at a home on 77 Old Souther Road in Horseshoe, North Carolina. This house had 2 bedrooms. In one of the bedrooms, deputies found a blue fanny pack lying on a bed. In that fanny pack, among other things found, was a prescription pill bottle containing 13 oval pills or tablets. Mr. Miller was taken into custody and gave what can only be described as a complete and full statement to law enforcement. He admitted that the bedroom where the fanny pack was his, and that the fanny pack was his. Subsequent analysis by the state labs indicated that the 13 pills contained hydrocodone, and that it was a trafficking amount or trafficking weight, hydrocodone, a little over 5 grams. As a result, Mr. Miller was arrested and charged with trafficking opium or heroin by possession of these 13 pills containing hydrocodone. It should be pointed out that the state's expert at trial testified these pills were actually 325 milligrams of acetaminophen, and 5 milligrams of hydrocodone. Mr. Miller pled not guilty. His case went to trial. At the close of the state's evidence and at the close of all the evidence, Mr. Miller moved to dismiss the charges against him. Specifically, though, he moved to dismiss the charge of trafficking opium or heroin by possession on the grounds that hydrocodone is an opioid, and opioids were not included in the trafficking statute at the time. Mr. Miller had been charged under North Carolina General Statute 90-95H4, which prohibited the trafficking in opium or opiates, but did not include opioids at the time. Mr. Miller's motions to dismiss were denied by the trial court. During the charge conference, during the charge conference, the trial court proposed instructing the jury that hydrocodone or any material, compound, mixture, or preparation which contains any quantity of hydrocodone is an opiate, or opioid. Mr. Miller objected to this instruction, claiming it was an incorrect statement of the law. The trial court overruled the instruction and instructed the jury accordingly. Mr. Miller was convicted of trafficking opium or heroin by possession of these 13 pills. He appealed to the North Carolina Court of Appeals. At the Court of Appeals, Mr. Miller made 2 arguments. He first argued that the trial court erred by denying his motion to dismiss the charge of trafficking opium or heroin by possession of these 13 pills because hydrocodone is an opioid, and opioids are not included in the trafficking statute at the time of the offense. He also argued that the trial court's instruction to the jury that hydrocodone is, for all intents and purposes, an opioid and was included in the trafficking statute was an incorrect statement of the law at the time. The Court of Appeals decision was split. The majority ruled that this was not a case of first impression. The majority relied on its case in the State v. Garrett, a 2021 case in which the Court of Appeals had found that the trafficking statute, 90-95H4, included the term opiates, had defined the term opiates as including opioids. As a result, the Court of Appeals said it was bound by the principle of stare decisis to follow the Court of Appeals decision Therefore, the Court of Appeals, the majority, found that opiates, as defined as in 90-95H4, was broad, but was not contradicted by the legislature's subsequent definition of opioids. The legislature in 2017 had defined opioids in 90-8718A as a purely synthetic substance. However, the Court of Appeals said the legislature did not narrow the definition of opiates, and so they reasoned the term opiates encompassed opioids. As a result, the majority found that hydrocodone qualifies as an opiate within the meaning of the statute 90-95H4 based upon its ruling in Garrett 4 years earlier. As a result, the Court of Appeals upheld the trial court's denial of Mr. Miller's motion to dismiss the charge and affirmed the trial court's instructions to the jury.
Seems to me, and correct me if I'm wrong, that the heart of your argument is that because the General Assembly in 2017 inserted a definition of opioid, that somehow that means that the definition of opiate is not broad enough to include opioids. Is that right?
The definition of opiates is broad, Justice Allen, but by the legislature specifically defining opioids, they set it apart. And when
it seems like a bit of a non sequitur to me. I mean, in other words, it doesn't seem to me that it necessarily follows that because the General Assembly created or inserted a definition of opioid, that somehow narrows the definition of opiate that was discussed in Garrett. If that had been the General Assembly's intent, wouldn't we have expected them to add some language to the definition of opiate, saying essentially opiate does not include opioid?
Well, actually, the legislature in 2018 included the word opioid in the trafficking statute 90-95H4. So it reads opiates, or opioids. So the legislature is making a distinction between...
But does that help you or hurt you?
Well, it would hurt me except for the fact that the statute was passed in June of 2018, but didn't take effect until December 1st of 2018, and this offense occurred November 8th of 2018, 22 days before the statute took effect. So what you have is a situation where the legislature is taking a definition of opiates. The definition has changed a little. Originally, when the Controlled Substances Act was passed in 1971, it just said opium. It was modified to say opium derivatives, excuse me. It then was expanded to opiates, and then it was expanded to opioids. The legislature has taken the time to not only define opioids, but to include it in the statute, thereby separating the two. And that was the basis of the dissent. The dissent, excuse me, said this was not a case of first impression. The dissent said because the legislature had defined opioids, that the court should look at the trafficking statute to see if opioids are still included in the term opiates. As a result, the dissent said the principle of stare decisis was not applicable here, and relied on this court's ruling in State v. Camp and others that says when the language of a statute is clear and without ambiguity, it is the duty of the court to give the plain meaning to the statute.
Well, I'm not nearly as good at hypotheticals as Justice Dietz, so maybe he can jump in if this one isn't illuminating. But suppose you have a law that applies to all fruit, and then you have a Court of Appeals case that says, well, that involves apples. And the court says, well, apples are a kind of fruit, and so the statute applies. And then the General Assembly comes along after that and puts in the statute a definition of apple. would that mean that an apple's not a fruit?
I'm not sure I follow your question.
In other words, the Court of Appeals had construed the term opiate, the definition of it, broadly enough to include opioid. Does the fact that, I'm struggling with the inference that the fact that the General Assembly then came along and defined opioid somehow narrows the pre-existing definition of opiate, which the General Assembly did not modify.
They did not.
So that's what I'm trying to get at with my hypo. You know, if it applies to all fruits, it applies to apples, and the fact that the General Assembly comes along later and gives you a definition of an apple doesn't render the pre-existing provision inapplicable to apples.
Well, I might disagree. If the legislature were to come back and change the definition of apples, then I think it would be the responsibility of this court to go back, well, not to go back, but from there on, look at apples a different way. I hope I'm answering your question. Let me put it this way, if I may.
Let me follow up, because I actually thought that was a good hypothetical, and now I'm
Okay.
thinking about it. So, my first question is, in the statutes that existed at the time this offense, the alleged offense, took place, did the definition of opiate exclude synthetic substances and limit it only to those that you derive from opium? Like, was that in the text of the statute?
No, in fact, the definition is very broad and all-encompassing. And that is the problem here, is it was written probably in the 1980s and encompassed a lot, and it hasn't been changed. But the legislature has taken the time to define opioids. And if we look at the actions of the legislature, we can see they have differentiated between opiates and opioids over time.
But I guess then getting back to the hypothetical, I mean, isn't the problem that at the time then you come back with a definition of opioids, and unless it very clearly said in there, and but an apple is this, and by the way, it's not a fruit, then why can't you fall into both categories at the same time?
Well, it could fall into categories at the same time, but the trouble is we're living in what I call in my brief a legal fiction. Opioids are purely synthetic products. They have no trace of opium in them. They are not derived from the opium poppy. That is what the legislature's definition in 9087 18A says. The problem is opiates are products that are derived from the poppy seed. That would include morphine, codeine, heroin. Those things are opiates. And the trouble is...
And so you're saying that the statute said that at the time of this crime. It said that opiates are only the substances that are derived from...
No, sir. What I'm saying
isn't that a problem for you, though?
It is, but we need to look at what society looks at opiates are. Because in my brief, I call this a legal fiction, because eventually the Court of Appeals, when we get to the Garrett case, the one the Court of Appeals relies on, the Court of Appeals is basically saying opioids is an umbrella term that refers to natural opioids, semi-synthetic opioids, and synthetic opioids. So, excuse me, I'm trying to fight off a little something here. The Garrett case was interesting because in Garrett, she actually possessed fentanyl. She went to the Court of Appeals and argued fentanyl is an opioid. It's not included in the trafficking statute. Now, when Garrett was heard, the term opioids had not been defined. Okay, so the Court of Appeals basically in Garrett looked at the definition of opioids, looked at all the definitions. They looked at the statutory definition, and they said it's broad enough to cover this. But when doing so, they reached some really unusual results. That is, opioid is an umbrella term used to refer to all natural, semi-synthetic, and synthetic opioids. The problem is, nobody really follows this. That's not the legislature's definition of opioids. It's, what we've got is an old definition of opiates, and then you've got a definition of opioids. Now, the legislature has taken time to list them separately in the statute. It says opium, opiates, or opioids. Now, if the legislature meant for opiates to be part of opioids, to be part of opiates, then there's no reason to put the two there separately.
But I guess isn't the response to that? I mean, so there's examples in the law of some really ridiculous definitions. I think the one that we often come back to is, I think it was in the Ninth Circuit, where they determined that environmental law meant that bees were a type of fish, because I guess fish had a definition that included like all invertebrates or something like that, and they said, well, insects are invertebrates. So if they want to, you can define a term in a statute in a way that's not what ordinarily people would think about it,
Mm-hmm.
and still, for purposes of criminal statute, even invoking the rule of lenity, if a criminal statute says, this is the contraband that you're not allowed to possess or whatever it is, and you look and it's covered, regardless of whether you think that's not normally what I'd call this thing. And so my question to you is, isn't it, I know this doesn't happen, but if you had gone and gotten a lawyer and saying, I want to sell this product, help me know, is this going to violate the controlled substances laws? And you were to look at the definition of opiate, wouldn't it cover opioids? Because they are sort of addictive forming, they're like morphine and so on. It's just that they're synthetic instead of being derived from opium, but that, for whatever reason, that's not in the statutory definition.
Yes, sir. I mean, the definition of opiate in 90-8718 is any substance having an addiction-forming or addiction-sustaining liability similar to morphine, or being capable of conversion into any drug having addiction-forming or addiction-sustaining liability. The only limitation there is morphine. And that encompasses probably things that are outside the scope of opium as well. I don't know. But what I do know is the legislature has, for years, differentiated between opiates and opioids. You look at the trafficking statute, I said, it refers to opium, opiates, opioids. When the legislature added the definition of opioids, it did so in the Synthetic Opioid and Other Dangerous Drug Control Act of 2017. Then the legislature, in the 2018, passed the Synthetic Opioid Act that included opioid in 90-95H4. But most notably is the legislature has treated opioids differently than opiates for a long time. For example, possession of fentanyl. Fentanyl is an opioid. It's purely synthetic. But in 2018, it was a misdemeanor. Mr. Miller possessed or was charged with possession of a fentanyl patch. That was a misdemeanor. Today it's a felony, but then it was a misdemeanor. Under the definition of opiates, that could have been a felony. Possession of methadone. Methadone's an opioid. It's purely synthetic, but in 2018, it was a misdemeanor. I believe today it's a felony. I have to be careful on that one. Suboxone. I think Suboxone's a synthetic one as well. It was a misdemeanor in 2018. I think today it is a misdemeanor for the first offense. But possession of heroin, which is an opiate, has and always has been a felony. That demonstrates, at least to me, that the legislature has differentiated these substances. Yes, Justice Dietz, I understand the problem. But the problem works both ways. The legislature took the time to define opioids, and the question is, why? Why did they do that? Why, when you have an all-expansive definition of opiates, would you take the time to specifically identify opioids? Because the definition for opioids is the exact opposite. It is very specific. Any synthetic narcotic drug having opiate-like activities, but is not derived from opium. That's what separates it from opiates, right there. It is not derived from opium. And I think it's important to point out that if you look at the jury instructions on trafficking opium or heroin say opiates, or opioids. The legislature is making a distinction between them, opiates and opioids.
What about, so if this definition was somehow meant to be a response to Garrett, in deciding that, should our analysis be informed by pretty common, I think, legislative practice of saying in legislation, we're overturning, the legislature will pass laws that in the title make it very clear that they're responding to particular cases? And should that inform our analysis, and was that done here?
It wasn't done here. I think I've got all your questions. Let me know if I don't answer them all. Garrett, well, first of all, opioids were defined in 2017. Opioids were included in the trafficking statute in 2018. The Garrett decision didn't come down until 2021. So this was not a response to the Garrett. Garrett actually, I think it should be pointed out, is a Court of Appeals decision. Garrett petitioned this court to review the Court of Appeals decision in Garrett, and this court denied that petition. So the Garrett case has no bearing here. It has no value as precedent. But the question, Justice Allen, is if a statute is unambiguous, this court has repeatedly said the words in the statute are to be given their plain meaning. And if the legislature has defined those definitions are to be followed. However, in Garrett, in Garrett, the court said the statute was ambiguous as to what is opiates, and therefore it was subject to definition or interpretation. If this court were to find that opiates is ambiguous, then you're subject to the rule of lenity, which requires strict construction. And because this is a criminal statute, and the statute should not go beyond that which was originally envisioned by the legislature.
And so can I just pick it up again on Justice Allen's hypothetical, just to make sure I understand? Your argument, trying to fit it into that hypothetical, would be this first section says fruits, and it has a definition of fruits. And then the legislature came back in and put like a subsection A, little a there, after, and said, apples are not a fruit. And so even though if we just applied the ordinary understanding of what an apple is, it would be covered in the fruits definition. Now there's another section that says, but this is not a fruit. And is that essentially what you're arguing here, that by having this very specific definition of opioid, even though if we didn't know about that, you could fit it into the opiate, you could fit opioids into the opiate definition, that it means they can no longer be there because they have their own definition? That's your argument?
If you were to take the definition of opiate and say it's encompassed by the definition of opioids, and is encompassed by the definition of opiates, you're basically telling the legislature this definition is a nullity. We've already defined opiates as being all-encompassing, and you're wasting your time telling us what opioids are. There's no point in it. I think the legislature...
But yes, and you're absolutely right about the timeline with Garrett. So thank you. But isn't that? It seems to me that may be your strongest argument, which is namely that it would be pointless for the legislature to have interpreted or given us a definition of opioid if opiate included it.
Yes, sir. Exactly. I mean, we have to presume the legislature does everything for a purpose, and they defined opioids in the Synthetic Opioid and Other Dangerous Control Act. The following year, they included the term opioid in the trafficking statute 90-95H4 in the opioid and other dangerous, I don't remember the name of the act, but it included opioid. So at some point, we have to recognize the legislature had a reason and a purpose for doing this. Are we going to recognize that purpose, or are we just going to keep going on our own way of saying it assume opiates covers everything? I see I'm at my time. I'd like to reserve my remaining time for rebuttal.
Thank you, counsel. We'll hear from that, Billy.
Good morning, Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. May it please the Court, my name is Jody Carpenter, Assistant Attorney General, and I represent the state in this matter. I'll address the first issue that this Court is reviewing. The state contends that the Court of Appeals did not err by affirming the trial court's denial of defendant's motion to dismiss the charge of trafficking opium by possession of hydrocodone on the grounds that hydrocodone is an opioid, and opioids are included in North Carolina General Statute Section 95H4. In State v. Garrett, the Court of Appeals interpreted 90-95H4 and held that opioids qualify as opiates within the meaning of the statute.
Can you answer that last question that had come up, which is if in 2017, when you add the definition of opioids, what is, if it's not being added to criminalize this substance that previously hadn't been there, what was the purpose of adding that?
And you're specifically referring to when the defining statutes of 90-87 changed.
Right. So it's like number 18 or whatever.
Right,
it's like 18A. You have a new one then.
So I think that the significant thing is how Garrett did refer to that. First of all, they did not change the definition of opiates at all. And then secondly, Garrett pointed out that that opiate in the 2016 version was ambiguous and likely led to more than one reasonable interpretation. So the General Assembly responded and to clarify. So Garrett has pointed out that the amendment was to clarify because of the ambiguous interpretation in the 2016 version. And so the state contends that the amendment was to clarify rather than alter the meaning of the term and to clarify the scope of substances that are covered by the statute.
So if they're clarifying like that, why not clarify 90-95 also and add opioids in there, if that was the purpose?
And we have to look at what all 90-87 applies to. And so, you know, I think if we should not specifically, it's a defining term for much more statutes than just 90-95. So I think just looking at the fact that they added a definition but did not change the opiate definition, we just have to go back to look at the issue with the apples. They did not exclude opioids in the definition of opiates. Did not change it at all. And if we have determined that opioids are included within that definition, then therefore they are still included in that definition. As it was not changed, it was not referenced at all. It was not altered at all. So the state contends that this case addresses rather the interpretation of 90-95H4 by the Court of Appeals in the Garrett case is appropriate for this case. The Court of Appeals interpretation of the statute in Garrett is very logical. The state contends it correctly interprets the sensible way of catching up with these types of drugs that were emerging on the street at the time. And the state contends that the facts of this case are not distinguishable from Garrett. And in Garrett, the Court of Appeals expressed that the legislator intended for a broader definition of opiates to apply, and therefore fentanyl applies. And Garrett stated the broader definition intended for opiates to include any drug that produces an opium-like effect by binding to opiate receptors in the brain, which would include drugs naturally derived from opium, such as morphine, and synthetic and semi-synthetic drugs, such as fentanyl. And the Court of Appeals did note that the term opiate is most commonly used as an umbrella term to refer to all natural, semi-synthetic, and synthetic opioids. And also, Garrett stated that the broader definition of opiate is supported in the Common Dictionary. And as this court stated in Dixon versus Russo, in the absence of a contextual definition, courts may look at dictionaries to determine the ordinary meaning of words within a statute. So Garrett talked a lot about the interpretation of the statute to determine how they come up with that broader definition that opioids should be included in the definition of opiates. And so the court, again, the state contends that following this same principle of Garrett, that the Court of Appeals was correct in affirming the denial of the motion to dismiss by the trial court, as hydrocodone is an opiate with this same statutory interpretation, and opiates are therefore included in 90-95H4. And again, this seems to be the most logical and sensible way to interpret the statute. And I would like to talk a little bit about Gibbs. We've talked a lot about Garrett, or Garrett has been mentioned a lot. Since the Garrett ruling by the Court of Appeals, this issue has also been addressed by the Court of Appeals in State v. Gibbs. On the date of the offense in Gibbs, which is a 2017 date of offense, the legislature had amended 90-87 to define opioids, but had not yet amended 90-95H4 to include opioids. And on remand in State v. Gibbs, the Court of Appeals held that the term opiate in the 2017 version of the statute is still broad enough to include synthetic opioids, such as fentanyl. The Court of Appeals stated in Gibbs on remand that 90-87 was amended in 2017. When it was amended in 2017 to add that definition of opioids, that did not change their analysis. So now we have Gibbs that has interpreted the statute the same way as Garrett, even with that additional definition of opioids. And on remand, the Court of Appeals noted that the issue in Gibbs were different from the issues in Garrett, but they were still guided by the Garrett court. And Gibbs also found, such as Garrett did, that when they found that fentanyl was an opiate as a matter of law, they concluded that the legislature's amendment of 90-95H4 in 2018, so now the 2018 amendment of the actual statute, was intended to clarify, not alter, the meaning of this term and to clarify the scope of the substances covered by the statute. So we have now two cases, yes, and they are Court of Appeals cases, and recognize that they do not have authority in this court, but I'm just pointing out that we have cases that have interpreted the statute they've interpreted and they've mentioned that the 2018 amendment was not meant for an alteration, but only for a clarification.
So we've sort of been searching for a why to you would do this. Is one possibility that the legislature, the plain text of opiate includes opioids, and the legislature always intended that. But a lot of the people that work in this field, like let's say the lab techs that have to test this to figure out what it is, they use their own scientific terms, and there was this thing, opioids, that the legislature had kind of defined as just an opiate, but chemically and technically it was not, and it was creating confusion. People were using these terms, and they said, well, let's just conform these controlled substances laws to sort of the lingo, if you want to think of it that way, of the experts that identify these substances. Is that a possibility?
That is very much a possibility. As when you look at the different testimony of the experts, they do start talking more about the actual scientific terms. And if you just do a common search of opioids and opiates, you will see that they are talked about interchangeably, and are referred to interchangeably, just in the the common knowledge or talk of opioids and opiates. So that is very much a very likely a possibility to make it more conform to scientific terminology.
Do we have to come up with a reason why the General Assembly would insert a definition of opioids, or is the question for us simply whether that definition is necessarily inconsistent with the definition of opiates?
Yes, I do not think that there has to be a reason announced or stated. Just as in, we have the 2 Court of Appeals cases that haven't, they just, opined that it was to clarify and not to alter based on their interpretation. So I do not think it has to be stated why, there is a separate definition for opioids, sorry. And significantly, the definition of opiates did not change. So, and I'd just like to point out a couple of things about some, how and I'm not sure if he'll address this, but I know he addressed it in his reply brief. Mr. Smith talks about how the state is trying to argue that this court is bound by the Garrett decision, and that is not what the state is doing at all. The state, is simply, looking at whether or not the Court of Appeals erred by affirming the trial court's denial of a motion to dismiss, but he points out that there's no controlling law on the issue presented in this case by this court. And the state agrees with that. So the state then looks at, there are 2 Court of Appeals decisions, Garrett and Gibbs, that have interpreted this statute logically and sensibly by finding that these highly addictive drugs, such as fentanyl and hydrocodone, are included in the definition of opiates in the statute. And it just makes sense that the state would point to these 2 cases and, just again, the common, Googling and looking, the terms opioids and opiates are commonly interchangeable. And it just makes logical sense that the legislature intended for this broader definition of opiates to apply to 90-95H4, as these drugs are highly addictive, as if we look at that definition in the dictionary of the opioids, being highly addictive. And so it just makes sense that we would not have overlooked drugs that are highly addictive, such as hydrocodone in this case. And hydrocodone is one of the most popular, or one of the highest addictive drugs at this time in the United States, or during this time in the United States.
Can I just ask you a question about whether there's a limiting principle to how we understand this definition of opiate in the statute? Because it says any substance having an addiction-forming or addiction-sustaining liability similar to morphine. So does that mean that the general, if for example, the science shows that alcohol is more addictive than morphine, we wouldn't say alcohol is an opiate, right?
No, you were correct about that. But just the similarities between these addictive drugs, and so not just the addiction part of it, but the other effects of opiates and opioids have similar effects, binding to cell receptors and so on and so forth. So I think addiction is very important, but there's also other parts to definitions as well.
So someone trying to understand what is legal and not legal, based on this definition, you're saying that part of what limits it is that it needs to be similar to morphine?
No, just the definition that is just. Well, let me see if I can go back to the specific Garrett. Garrett found that the broader definition intended for opiates is any drug that produces an opium-like effect by binding to opiate receptors in the brain, which would include drugs naturally derived from opium and synthetic and semi-synthetic drugs. So more so looking at the opium-like effect by binding to receptors in the brain is the issue with that. And then in addition to that, the highly addictive nature of the drugs as well. So just to, and
where in the statute would Garrett have gotten all that other than from saying similar to morphine?
Well, I think they also looked at the dictionary in the Merriam-Webster dictionary in Garrett to come up with some of their interpretation, as they said that they were allowed to do so by other cases, to look at the common meaning of the drugs and or look at the dictionary definition. So they did a combination of things.
Well, that doesn't make a lot of sense to me, because if the legislature defines a term and says it's criminal to possess this, you couldn't figure out whether you had violated that crime. Look at what a dictionary says that term means, right? You would have to use the term in the criminal statute.
Understanding, but yes, but they were interpreting the statute and looking at a combination of things.
But I mean, I'm not sure why you need to go there, because isn't hydrocodone, all of these opioids are like morphine in a way that alcohol would not be, or other types of controlled substances that are listed in the statute.
Right. Yeah, you're correct. I guess we're just, trying to, the definition of opiate from the Merriam-Webster dictionary is a synthetic or semi-synthetic drug that binds opiate receptors and produces the physiological effects like those of opium derivatives. So, I mean, I think looking at the Merriam-Webster dictionary helped with the interpretation of the statute. And then Chapter 90-8718 defined opiates as being similar to morphine and being capable of conversion into a drug having addiction, form, and liability. So there's more than just the addiction part of it. There's also the opiate, the synthetic or semi-synthetic drug that binds to opiate cell receptors and produces the same effects like those of opium derivatives. So there's a combination of things that the court in Garrett looked at to interpret the statute, a wide variety of things. So, in conclusion, well, I'll address the second issue briefly. Sorry, let me get to that. I do not think much time needs to be spent on the second issue because it is so closely tied to the first issue, but the state contends that the Court of Appeals did not err in finding the trial court's instruction to the jury that opioids are included in 90-95H4 was a correct statement of the law. The jury instruction was based on the law arising from the evidence, based on using the same interpretation from Garrett and Gibbs that opioids are included in the definition of opiates. And both of those cases have stated that the fact that the defining term, Gibbs stated that the fact that the defining terms in 90-87 changed from 2016 to 2017 does not change this statement of the law. And so, one second. So in conclusion, the state is asking for for this court to uphold the Court of Appeals decision. And unless there are any other questions, I'll turn it over to Mr. Smith for rebuttal.
Thank you, counsel. Rebuttal.
Thank you. Listening to the state's argument, I realized we have two competing definitions here. A definition for opiates, which is broad, and a definition for opioids, which is narrow. Opiates was included in the statute when Mr. Miller was charged. Opiates were not. But opiates were defined at the time. And the question is, which definition do we apply? Do they contradict each other? Are they complementary to each other? Unfortunately, I haven't seen any cases that really give us much guidance, except where this court has said in State v. Boykin, where the statute itself contains a definition of a word, that definition controls. Now, Chapter 90 has the definition section in 9087, and then the trafficking statute in 9095 H4. Opioids is defined, but it's not in the trafficking statute. I think that's relevant. The question, I think, for this court will be, do you interpret opiates broadly to bring in opioids, or do you interpret opioids narrowly to say this is what they are?
Can you give us a reason why the General Assembly wouldn't have wanted opioids to be included in 90-95H?
Well, they did want opioids included in 9095H4. In June of 2018,
Right.
they amended the statute.
I mean prior to that.
I think because opioids are a fairly new development. They didn't really hit the scene until the late 1990s with the Sackler family and Purdue Pharma, and with the coming of oxycodone, Oxycontin, and those substances. And the legislature was slow to respond. I mean, as I said a few minutes ago, possession of fentanyl was a misdemeanor in 2018. I think today we rub our heads in disbelief at that. Methadone was a misdemeanor. Suboxone's still a misdemeanor on the first offense. The question isn't, well, I take that back. The problem is this court must determine how you will define and apply opioids. In the Garrett case, the Court of Appeals said opioid was an umbrella term used to refer to all natural, semi-synthetic, and synthetic opioids. I can't find that definition anywhere except in the Court of Appeals decision in Garrett. In my brief, we call this a legal fiction because nobody really says opioids is an umbrella term. It contradicts the specific definition of our legislature. We should honor the wishes of our legislature and recognize they've defined opioids and apply it, whether as it was written, not as we would want it to be. For that reason, I'm going to ask you to reverse the Court of Appeals decision, vacate Mr. Miller's conviction for trafficking opium or heroin by possession. Thank you.
Thank you, counsel. Clerk.
All rise.